I was standing on my front porch in Columbus, Ohio, sipping my morning coffee when I noticed something that made my blood run cold. The Support Our Troops banner that had been hanging proudly on my garage for the past 3 months was gone. Not fallen down, not blown away by wind. Just gone, leaving behind only the hooks I had carefully installed back in March. My name is Derek Morrison, and I had lived in the Willowbrook Commons subdivision for 5 years without any major issues. Sure, the Homeowners Association sent the occasional passive-aggressive letter about my grass being a half-inch too tall or my trash cans being visible from the street for more than 12 hours after pickup, but nothing too serious. My wife Sarah had passed away 2 years ago from cancer, and my son Jake was serving his second tour in Afghanistan with the Army. That banner meant everything to me. It was not just a piece of fabric. It was a daily reminder that I was not alone in counting down the days until Jake came home safely. I set my coffee cup down on the porch railing and walked toward the garage, my heart pounding. Maybe it had fallen and blown into the bushes. I searched the azaleas, checked behind the garbage bins, even looked in the recycling container. Nothing. That is when I saw the invoice tucked into my front door, flapping slightly in the April breeze. The letterhead read Willowbrook Commons HOA in an obnoxiously fancy script. My hands shook as I unfolded it. The letter was from Patricia Henderson, the HOA president, a woman in her early 50s who treated the neighborhood like her personal fiefdom. I had seen her at community meetings, always dressed in expensive pantsuits, her blonde hair styled in that aggressive bob that screamed, "I want to speak to the manager." The letter was dated yesterday. "Dear Mr. Morrison," it began in that saccharine tone that barely concealed contempt. "It has come to our attention that you have been displaying unauthorized signage on your property in violation of Willowbrook Commons HOA Covenant Section 7.3, which explicitly prohibits any banners, flags, except the American flag on approved holidays, signs, or displays without prior written approval from the Architectural Review Committee. Your military support banner was removed on April 18th at 3:00 p.m. by our contracted maintenance team. You are hereby billed $275 for the removal service, plus a $150 violation fine. Please remit payment within 30 days to avoid additional penalties and potential legal action. The banner has been disposed of per HOA policy regarding non-compliant materials." I read the letter 3 times, each time feeling my anger rise like a thermometer in boiling water. They had thrown away my banner, the one I had bought specifically to honor Jake. The one that had his unit number embroidered on it. The one that cost me almost $200 because I wanted it to be perfect and durable enough to last through his entire deployment. I stormed back inside and grabbed my phone, pulling up the HOA covenant documents I had received when I purchased the house. I had never actually read through all 78 pages of single-spaced legalese, but I was about to become very familiar with Section 7.3. After 20 minutes of searching, I found it. The section did mention restrictions on signage, but there was nothing explicit about military support banners. The language was vague, talking about commercial advertisements and temporary event signage. There was a mention of flags, but it specifically stated that the American flag could be displayed year-round, and it made no mention whatsoever of other patriotic displays. I called the HOA office immediately. The phone rang 6 times before someone picked up. "Willowbrook Commons HOA, this is Brenda speaking. How may I help you today?" The voice was chipper in that artificial customer service way. "This is Derek Morrison at 4782 Maple Ridge Drive. I need to speak with Patricia Henderson immediately." "I am sorry, but Mrs. Henderson is in a meeting right now. Can I take a message or help you with something? She can help me by explaining why she had my property destroyed and then billed me for it. She had no right to remove my banner. It was not violating anything. There was a pause, and I could hear papers shuffling. Oh yes, I see the note here. Mr. Morrison, the banner was in violation of Covenant Section 7.3. All exterior displays require approval. That section is about commercial signage. My banner was not commercial. It was a patriotic display supporting my son who is currently serving in Afghanistan. Another pause, longer this time. Sir, I understand you are upset, but the covenants are very clear. If you would like to contest the fine, you can submit a written appeal to the board, and they will review it at the next quarterly meeting. The next quarterly meeting? That is not until July. I want this resolved now, and I want my banner back. I am afraid the banner was disposed of according to policy. But you are welcome to submit your appeal, and I hung up before she could finish. My hands were trembling with rage. I had never been the type to make waves or cause trouble, but this was different. This was personal. They had crossed a line, and I was not going to let it go. I spent the rest of the morning researching. I was a high school history teacher, not a lawyer, but I knew enough about constitutional law to understand that the First Amendment protected free speech, even in private communities to some extent. I started digging through court cases, finding precedents where HOAs had been challenged and lost on First Amendment grounds. There was the Freedom to Display the American Flag Act of 2005, which protected the right of homeowners to display the flag, but my banner was not technically a flag. Then I found it. A case from Texas in 2018 where a homeowner had successfully sued their HOA for removing a military support banner. The court had ruled that such displays were protected speech and that HOAs could not prohibit them under the First Amendment, especially when the covenants were vague or overreaching. My pulse quickened as I read through the decision. This was exactly what I needed. I called a lawyer that afternoon. His name was Robert Chen, and he had been recommended by a colleague at school who had used him for a property dispute. Robert's office was in a modest building in downtown Columbus, and he agreed to see me the next day. When I arrived at his office, Robert greeted me with a firm handshake. He was in his mid-40s, with sharp eyes behind wire-rimmed glasses and a no-nonsense demeanor that immediately put me at ease. I explained the situation, showing him the letter from Patricia, the covenant documents, and the research I had done. He listened carefully, occasionally making notes on a yellow legal pad. When I finished, he leaned back in his chair and tapped his pen against the desk. "This is interesting," he said finally. "HOAs operate in a weird legal space. They are private entities, so normally the First Amendment would not apply because it restricts government action, not private parties. However, there are exceptions. When an HOA acts with the authority typically reserved for government, performing essential municipal functions like maintaining roads and enforcing regulations, courts have sometimes found that they are state actors subject to constitutional restrictions. So you are saying I have a case? I am saying you might. The key will be demonstrating that your banner is protected speech and that the HOA's covenant is either unconstitutionally vague or overbroad. We can also argue selective enforcement if they have allowed other displays. Have you noticed any other banners, signs, or decorations in the neighborhood? I thought about it. Yeah, actually. The Johnsons 3 houses down have a big wooden sign in their front yard that says "Welcome to our home" with their family name on it. The Parkers across the street have seasonal decorations up almost year-round. Halloween stuff, Christmas lights, Easter bunnies, And Patricia herself has this elaborate garden flag setup that she changes every month. Robert smiled for the first time. Selective enforcement. That is perfect. If they are allowing some displays but not others based on content, that is viewpoint discrimination, which is absolutely prohibited under First Amendment doctrine. How quickly do you want to move on this? As fast as possible. They want me to wait until July for a board meeting, but I do not want to wait that long. And honestly, I cannot afford to. My son is supposed to come home on leave in June, and I wanted that banner up when he gets here. We can file for an emergency injunction and a declaratory judgment. Essentially, we will ask the court to rule that the HOA's action was unconstitutional and to order them to stop enforcing this provision of the covenant. Given the First Amendment issues, we might be able to get a hearing scheduled quickly. Federal court would be better for this, but we can start in state court and see how it goes. How much is this going to cost me? Robert named a figure that made me wince, but I nodded. Do it. I am not letting them get away with this. Over the next week, Robert prepared the legal filings. I provided him with photographs of all the other displays in the neighborhood, copies of my correspondence with the HOA, and a detailed affidavit explaining the significance of the banner and my son's military service. Robert also subpoenaed the HOA's records to see how they had enforced Section 7.3 in the past. Meanwhile, Patricia was not backing down. I received another letter, this time threatening to place a lien on my property if I did not pay the $425 by the end of the month. I forwarded it to Robert, who assured me that they could not actually do that while the case was pending, but the threat still made my stomach churn. The preliminary hearing was scheduled for May 10th, less than 3 weeks after the banner had been removed. Robert had filed in Franklin County Common Pleas Court, arguing that the case involved state constitutional issues as well as federal ones. The judge assigned to the case was Judge Margaret Stevens, a fair-minded jurist with a reputation for taking free speech issues seriously. The night before the hearing, I barely slept. I kept running through everything in my mind, worrying that I had missed something or that the judge would not see things my way. I thought about Jake, wondering if he even knew what was happening back home. I had not told him about the banner situation because I did not want him to worry about anything except staying safe. The courthouse was imposing, all marble columns and echoing hallways. Robert met me outside the courtroom, looking confident in a dark blue suit. Remember, you might be called to testify. If you are, just answer the questions honestly and directly. Do not get emotional or angry, even if their lawyer tries to provoke you. Who is their lawyer? A guy named Timothy Walsh from a firm that specializes in HOA law. He is good, but he is going to have a hard time defending this one. We entered the courtroom, and I saw Patricia sitting at the defense table with Walsh, a balding man in his 60s with the smug expression of someone who has won too many cases against unrepresented homeowners. Patricia glanced at me with barely concealed disdain, then whispered something to Walsh. Judge Stevens entered, and we all stood. She was a woman in her late 50s with steel gray hair and an air of authority that filled the room. Please be seated. We are here for Morrison v. Willowbrook Commons HOA, case number CV 2026-3847. This is a preliminary hearing on the plaintiff's motion for emergency injunctive relief and declaratory judgment. Mr. Chen, you may proceed. Robert stood and approached the podium. Thank you, Your Honor. This case is about a fundamental constitutional right, freedom of speech. My client, Derek Morrison, is a widower whose only son is currently serving in the United States Army in Afghanistan. To honor his son's service, Mr. Morrison displayed a military support banner on his garage, a banner that contained no commercial content, no obscenity, no fighting words, nothing that would fall outside First Amendment protection. The Willowbrook Commons HOA, acting through its president Patricia Henderson, unilaterally removed and destroyed this banner, then billed my client $425 for the privilege of having his constitutional rights violated. Walsh objected immediately. Your Honor, this is not a constitutional issue. The First Amendment restricts government action, not private contractual agreements. Mr. Morrison voluntarily agreed to abide by the HOA covenants when he purchased his property. This is simply a breach of contract case. Judge Stevens held up her hand. I will hear the arguments, Mr. Walsh. Mr. Chen, please continue. Your Honor, while it is true that the First Amendment typically applies to government actors, Ohio courts have recognized that HOAs can be subject to constitutional scrutiny when they perform functions traditionally reserved for government. Willowbrook Commons maintains private roads, enforces regulations affecting property use, and exercises powers delegated to it by the county. In Shelley v. Creamer, the Supreme Court held that judicial enforcement of private discriminatory covenants constitutes state action. Similarly, here, if this court were to enforce the HOA's content-based restriction on speech, it would constitute state action subject to First Amendment scrutiny. Robert was just getting started. He pulled out a thick binder and began walking the judge through the case law. He cited the Texas case I had found, as well as several others from around the country, where courts had struck down HOA restrictions on patriotic displays. He also pointed out the selective enforcement issue, presenting the photographs of other displays in the neighborhood that had never been challenged. Your Honor, Robert continued, the HOA's own records, which we obtained through discovery, show that Section 7.3 has been enforced exactly 3 times in the past 5 years. Once against a homeowner who put up a for sale sign that was too large. Once against someone who displayed a political campaign banner during election season. And now against my client for a military support banner. Meanwhile, as these photographs show, there are at least 15 homes in Willowbrook Commons with various signs, banners, flags, and displays that have never been challenged. The only common thread is that the HOA appears to target speech it finds objectionable while ignoring displays it approves of. That is the definition of viewpoint discrimination. Walsh stood to respond, and his argument was exactly what I expected. He claimed that HOAs were necessary to maintain property values, that homeowners had freely agreed to the restrictions, and that allowing one person to violate the covenants would open the floodgates to chaos. He also argued that the covenant language was clear, and that my banner violated it regardless of selective enforcement. Your Honor, Walsh said, his voice dripping with condescension, if we allow Mr. Morrison to ignore the covenants because he disagrees with them, what is to stop every homeowner from doing the same? The whole purpose of an HOA is to maintain uniformity and standards. Mr. Morrison knew these rules when he moved in. Judge Stevens interrupted him. Mr. Walsh, I have read the covenant provision in question. Section 7.3 talks about prohibiting commercial signage and temporary event displays. How exactly does a military support banner fall under either of those categories? Walsh stammered slightly. Well, Your Honor, the provision also requires prior approval for any exterior displays. Mr. Morrison never sought approval. Did he know he needed approval? Is there anything in the covenant that explicitly states military or patriotic displays require approval? The covenant requires approval for all displays, Your Honor. Except the American flag. Correct. Section 7.3 specifically exempts the American flag. Why would the drafters include that exemption if they intended to prohibit all patriotic displays? I could see Walsh struggling. The American flag is different, Your Honor. It is the national flag. Other displays, even patriotic ones, are not the same. Judge Stevens did not look convinced. She turned to Robert. Mr. Chen, what specific relief are you seeking? Your Honor, we are asking for 3 things. First, a declaratory judgment that Section 7.3 of the Willowbrook Commons Covenants, as applied to non-commercial patriotic displays, violates the First Amendment and the Ohio Constitution. Second, an injunction prohibiting the HOA from enforcing this provision against my client or any other homeowner displaying similar protected speech. And third, damages for the cost of the destroyed banner and emotional distress, plus attorney's fees under 42 U.S.C. Section 1983, which allows recovery of fees in civil rights cases. Judge Stevens made notes, then looked at both lawyers. Here is what I am going to do. This case raises significant constitutional questions that deserve a full hearing. However, the preliminary issue is whether Mr. Morrison is likely to succeed on the merits, and frankly, Mr. Walsh, I think he is. The covenant language is vague, the enforcement has been selective, and the speech in question is clearly protected under any reasonable First Amendment analysis. I am granting the preliminary injunction. The HOA is hereby ordered to cease enforcing Section 7.3 against Mr. Morrison or any other homeowner displaying non-commercial patriotic or political speech. Mr. Morrison, you are free to put up a new banner, and the HOA cannot touch it. I felt a wave of relief wash over me, but Judge Stevens was not done. Furthermore, I am scheduling a full hearing on the declaratory judgment and damages claims for June 15th. Mr. Walsh, I suggest you advise your client to seriously consider settling this case. If I find that the HOA violated Mr. Morrison's constitutional rights, you are looking at not just damages but also attorney's fees, which could be substantial. And if I issue a declaratory judgment striking down Section 7.3, it will affect every homeowner in Willowbrook Commons, not just Mr. Morrison. Your board needs to think long and hard about whether they want to fight this. Walsh looked like he had swallowed something sour. Yes, Your Honor. One more thing, Judge Stevens added, her tone hardening. The HOA billed Mr. Morrison $425 for removing his banner. That bill is hereby voided, and the HOA is ordered to send written confirmation to Mr. Morrison within 7 days that no payment is owed and no lien will be placed on his property. If I hear that the HOA has taken any retaliatory action against Mr. Morrison, I will not be pleased. Are we clear? Yes, Your Honor, Walsh muttered. Good, we are adjourned. The gavel came down and I turned to Robert, unable to keep the grin off my face. We won. We won the preliminary round, Robert cautioned, but he was smiling too. The real fight is the damages claim. But yes, this is a good day. As we left the courtroom, Patricia stormed past me without making eye contact, her face flushed with anger. Walsh followed, his phone already pressed to his ear. Robert and I stopped in the hallway and he shook my hand. Go buy a new banner and put it up today. Make it bigger than the last one if you want. They cannot touch you now. I drove straight to a military supply store and bought the biggest, most beautiful support our troops banner they had. This one was even better than the original, with a full-color American flag design and bold yellow letters that read Proud Army Dad, along with a space where I could add Jake's name and unit. The clerk, a veteran himself, gave me a discount when I explained what had happened. By late afternoon, The new banner was hanging on my garage, even more prominent than the first. I stood back and admired it, feeling a sense of satisfaction I had not experienced in a long time. Several neighbors came by to congratulate me, saying they had heard about the court hearing through the neighborhood grapevine. Apparently, Patricia's defeat was already big news in Willowbrook Commons. The next week, I received a certified letter from the HOA's law firm confirming that the $425 bill had been voided and that no action would be taken against my property. It was a small victory, but it felt good to have it in writing. However, Patricia was not done making my life difficult. A few days later, I got a notice that my trash cans had been left visible from the street for more than 12 hours, which was a violation of Covenant Section 4.7. Then another notice about my grass being too long, even though I had mowed it just 3 days earlier. And then a complaint that my mailbox needed repainting, citing Section 9.2. It was obvious what she was doing. She could not touch my banner anymore, so she was going to harass me with every minor violation she could dream up. Each notice came with a $50 fine, and I knew that if I ignored them, she would try to use them as ammunition later. I called Robert and explained the situation. He laughed, which surprised me. "Derek, this is actually perfect. She is engaging in retaliation, which is going to make our damages case even stronger. Keep every single one of these notices. Document everything. Take photos with timestamps. If she keeps this up, we can add a retaliation claim to the lawsuit." And Patricia did keep it up. Over the next 2 weeks, I received 8 more violation notices for things that ranged from petty to absurd. One claimed that my front door wreath was not an approved color. Another said that my garden hose was visible from the street. The most ridiculous one claimed that I had parked my car in my own driveway at an improper angle. I meticulously documented everything, just as Robert had instructed. I also started noticing that Patricia was driving by my house multiple times a day, clearly looking for anything she could cite me for. My neighbor, an older woman named Helen Rodriguez, confirmed that Patricia had been asking her questions about me, trying to dig up dirt. The June 15th hearing arrived, and this time the atmosphere was different. Walsh looked tired, and Patricia looked nervous. Robert had submitted a motion to add the retaliation claim, along with all the documented evidence of Patricia's harassment campaign. Judge Stevens had reviewed everything in advance, and she did not look happy when she took the bench. "Mr. Walsh, I have reviewed the supplemental filings in this case, and I am disturbed by what I see. The HOA has issued 13 violation notices to Mr. Morrison in the past month, many of them for infractions that are either trivial or questionable. Can you explain this sudden interest in Mr. Morrison's property maintenance?" Walsh cleared his throat. "Your Honor, the HOA has a duty to enforce the covenants uniformly. These are all legitimate violations." "Really? His garden hose was visible. His car was parked at an improper angle in his own driveway. Come on, Mr. Walsh. This is textbook retaliation, and you know it." "Your Honor, Mrs. Henderson takes her role as HOA president very seriously. She is simply doing her job." Judge Stevens turned her attention to Patricia, who was sitting ramrod straight in her chair. "Mrs. Henderson, you are under oath. Have you issued a similar volume of violation notices to any other homeowner in Willowbrook Commons in the past month?" Patricia hesitated, then spoke in a tight voice. "I have issued notices to several homeowners, Your Honor." "How many notices total?" Another pause. "Including Mr. Morrison's, approximately 18. "So 13 of those 18 were to Mr. Morrison. That is 72% of your enforcement activity directed at one homeowner who just happens to have successfully challenged your authority in court. Do you see how that looks?" Patricia's face turned red. "I am simply enforcing the rules, Your Honor. Mr. Morrison seems to think he is above them. Or perhaps you are using the rules as a weapon because you are angry that he stood up to you. That is what retaliation looks like, Mrs. Henderson." The hearing proceeded with testimony from both sides. I took the stand and described the harassment campaign, showing the judge photographs of my violations next to similar or worse conditions at other houses that had never been cited. Robert called Helen Rodriguez as a witness, and she testified that Patricia had indeed been asking invasive questions about me, and had told her that I was a troublemaker who needed to be put in his place. That testimony was damning. Walsh tried to rehabilitate Patricia by having her testify about her dedication to maintaining property values and neighborhood standards, but it only made things worse. Under cross-examination from Robert, Patricia became defensive and hostile, at one point actually saying that military banners were tacky and brought down the neighborhood aesthetic. Robert pounced on that. "So your objection is not really about the covenant violation, is it, Mrs. Henderson? You just do not like the message on Mr. Morrison's banner." "That is not what I said. You said military banners are tacky. That is a content-based judgment. You are admitting that you removed his banner because you did not approve of what it said." "I removed it because it violated the covenants. But you allow other displays that also violate the covenants, according to your interpretation. The only difference is that you like some displays and dislike others. That is viewpoint discrimination, and it is unconstitutional." Patricia had no good answer to that. She stepped down from the witness stand looking defeated. Judge Stevens did not take long to reach her decision. "I am ruling in favor of Mr. Morrison on all counts. First, I find that Section 7.3 of the Willowbrook Commons Covenants, as applied to non-commercial patriotic displays, is unconstitutionally vague and has been enforced in a manner that constitutes viewpoint discrimination. The HOA is permanently enjoined from enforcing this provision against such displays. Second, I find that the HOA, acting through Mrs. Henderson, has engaged in clear retaliation against Mr. Morrison, which violates his rights and constitutes an abuse of HOA authority. Third, I am awarding Mr. Morrison damages in the amount of $2,500 for the destroyed banner, emotional distress, and harassment. Fourth, I am awarding attorney's fees and costs in the full amount of Mr. Chen's reasonable fees, which appear to be approximately $8,000 based on the billing records submitted. Finally, I am ordering the HOA to adopt a clear written policy regarding patriotic displays that complies with constitutional requirements, and to provide training to its board members on First Amendment issues. I could hardly believe what I was hearing. Not only had I won, but the judge was hitting the HOA where it hurt, their wallet. But Judge Stevens was not finished. "Mrs. Henderson, I want to be very clear about something. You are in a position of authority in your community, and with that authority comes responsibility. You cannot use your position to punish people who disagree with you or exercise their constitutional rights. What you did to Mr. Morrison was wrong, and it needs to stop. If I hear that you have continued to harass him or any other homeowner who chooses to display patriotic messages, I will consider holding you personally liable, not just the HOA. Do you understand?" Patricia nodded, her eyes downcast. "Yes, Your Honor." "Good. The HOA has 30 days to pay the damages and attorney's fees. Mr. Morrison, I hope your son returns home safely, and I hope that banner is still flying when he does." "Thank you, Your Honor," I managed to say, my voice thick with emotion. As we left the courthouse, Robert was ecstatic. That was as complete a victory as you could possibly get. Damages, fees, injunction, declaratory judgment, and the judge absolutely destroyed them on the record. This is going to set a precedent for HOA cases in Ohio. "I just wanted my banner back," I said, but I was smiling. "Well, you got that and a lot more. The HOA is going to have to pay you $10,500 total. That is not a bad outcome." Over the next few weeks, word of the case spread throughout Willowbrook Commons and beyond. I started getting calls from neighbors who had their own grievances with Patricia and the HOA board. Apparently, my case had opened the floodgates. People who had been afraid to speak up were now coming forward with stories of harassment, selective enforcement, and abuse of power. A group of homeowners organized a recall election to remove Patricia from the board. Under the HOA bylaws, a recall required signatures from 30% of homeowners and then a majority vote. They got the signatures within 2 weeks. The vote was scheduled for August, but Patricia resigned before it could take place, issuing a terse statement about pursuing other opportunities. Her resignation was not the end of the story, though. The new board president, a reasonable guy named Martin Foster who worked as an accountant, reached out to me personally to apologize for what had happened. He also asked if I would be willing to serve on a committee to revise the HOA covenants to make them clearer and more fair. I agreed, figuring that if I was going to live in this neighborhood, I might as well help make it better. The check from the HOA arrived in mid-July, exactly 30 days after the judgment. $10,500, which more than covered my legal fees and compensated me for the nightmare I had been through. I used part of it to buy a second banner, this one reading "Welcome Home, Jake," which I planned to hang up the day my son returned from deployment. Jake called me a few days later, using the satellite phone at his base. "Dad, I heard about what you did. Mom would have been proud." Those words meant more to me than the court victory, the money, or anything else. I just could not let them disrespect what you are doing over there. "I know, Dad, and I appreciate it, but please do not make any more enemies while I am gone, okay? I want to come home to a peaceful neighborhood." I laughed. "Too late for that, but do not worry. Things are getting better." In late August, Jake came home on leave. The day he arrived, I had both banners up, along with a huge American flag on a proper flagpole that I had installed in the front yard. The new HOA board had not only approved it, but had actually sent me a congratulatory note. Jake's homecoming was everything I had hoped for. The neighbors threw a block party, and people I had never even spoken to came by to shake his hand and thank him for his service. Even some of Patricia's former allies showed up, apparently feeling guilty about how things had gone down. Jake stood in front of the house, looking at the banners and the flag, and I saw tears in his eyes. "You did not have to do all this, Dad." "Yes, I did. You are my son, and I am proud of you." Nobody gets to tell me I cannot say that. The story could have ended there, but there was one more twist. In September, I got a call from a reporter at the Columbus Dispatch who had heard about the case. She wanted to do a feature story about HOAs and constitutional rights, using my case as the centerpiece. I agreed, and the article ran on the front page of the Sunday edition. The response was overwhelming. I received letters and emails from people all over Ohio who had similar experiences with their HOAs. Some had been fined for displaying religious symbols, others for political signs, and several for patriotic displays like mine. A few had been told they could not fly the American flag, which was actually illegal under federal law but still happened because people did not know their rights. Robert contacted me about possibly filing a class action lawsuit against multiple HOAs in Ohio for systematic First Amendment violations, but I declined. I had gotten what I wanted, and I did not have the energy for another legal battle. However, I did agree to speak at a few community forums about HOA reform and homeowner rights. One of those forums was in Cleveland, and in the audience was a state representative named Jennifer Wallace. After my presentation, she approached me and said she was drafting legislation to reform HOA laws in Ohio, including requiring clear protections for patriotic displays and limiting HOA's ability to fine homeowners for minor violations. She asked if I would be willing to testify before the state legislature if the bill moved forward. Absolutely, I said without hesitation. The bill, which became known as the Homeowner Free Speech Protection Act, was introduced in the Ohio House in October. It had bipartisan support, which was rare these days, and moved through committee fairly quickly. In December, I traveled to the State House in Columbus and testified before the Judiciary Committee. I told them my story, showing them pictures of the banners and explaining what it meant to have my son serving overseas. I talked about the harassment from Patricia and the HOA, and how the court case had vindicated my rights, but should never have been necessary in the first place. I argued that homeowners should not need to hire a lawyer and go to court just to express support for their family members in the military. The committee members asked thoughtful questions, and several of them thanked me for my testimony. One representative, a military veteran himself, said that my case had inspired him to co-sponsor the bill. The Homeowner Free Speech Protection Act passed the House in February of the following year by a vote of 87-12. It went to the Senate, where it faced some opposition from HOA industry groups who claimed it would make covenants unenforceable. But the bill's supporters rallied, and it passed 28-5 in March. The governor signed it into law in April, almost exactly 1 year after Patricia had torn down my first banner. The new law did several things. It explicitly protected the right of homeowners to display the American flag, military service banners, and religious symbols without HOA approval. It limited HOA's ability to fine homeowners for minor violations, and required a warning notice and opportunity to cure before any fine could be imposed. It also prohibited HOA retaliation against homeowners who challenged board decisions, with penalties including personal liability for board members who engaged in harassment. When I heard that the governor had signed the bill, I called Jake, who was back in Afghanistan for his third tour. The law passed. No HOA in Ohio can do what Patricia did to us ever again. That is amazing, Dad. You really made a difference. We made a difference. None of this would have happened if you were not over there serving. People need to be able to honor that. After Jake returned from his deployment for good, he decided to settle in Columbus and go back to school using his GI Bill benefits. He rented an apartment at first, but eventually he bought a house in a different neighborhood, one without an HOA. He joked that he had seen enough bureaucracy in the Army and did not need it in his personal life too. As for me, I stayed in Willowbrook Commons. The neighborhood had changed for the better after Patricia's departure. The new board was reasonable, focused on actual community improvement rather than petty enforcement actions. They repaved the roads, upgraded the playground, and organized regular social events that brought people together instead of driving them apart. I kept teaching history at the high school, and I often used my own experience as a case study when we covered the First Amendment. My students were fascinated by the story, and it helped make constitutional law real and relevant to their lives. Several of them told me they had shared the story with their parents, some of whom lived in HOA communities and had never thought about their rights. The banner stayed up on my garage year-round, weathering storms and seasons. I replaced it every couple of years as it faded, but there was always a banner there. It became a neighborhood landmark of sorts, a symbol of the fight for free speech and the importance of standing up for what you believe in. I ran into Patricia one more time, about 2 years after the court case. I was at the grocery store, loading bags into my car when I saw her in the parking lot. She looked older, more tired, and she avoided eye contact, but as she walked past, she stopped and turned to me. "I owe you an apology," she said quietly. "What I did was wrong. I let my ego and my need for control override common decency. Your son was serving his country and you had every right to honor that. I am sorry." I was stunned. This was the last thing I had expected. "Thank you for saying that. It means a lot." She nodded, then continued to her car without another word. I never saw her again, but that brief moment of acknowledgement brought a sense of closure I had not realized I needed. The legal victory, the law change, and even Patricia's apology were all important, but the real victory was simpler than that. It was the ability to stand on my porch every morning, coffee in hand, and see that banner flying proudly. It was the conversations with neighbors who felt empowered to express themselves without fear. It was the letters from strangers telling me that my story had inspired them to fight back against injustice in their own lives. And it was knowing that when Jake looked at that banner, he saw more than just fabric and thread. He saw a father's love, a community's support, and proof that even when powerful people try to silence you, the Constitution and the courts will back you up if you are willing to fight. The First Amendment won my case in one hearing, just like the judge said it would. But the fight for free speech is never really over. It continues every day in small ways and large whenever someone stands up and says, "I have the right to express myself, and you cannot take that away from me." That is what I did, and that is what the banner represents. Not just support for the troops, though it certainly is that, but also a reminder that rights are not just words on paper. They are real, they matter, and they are worth defending, no matter how powerful the people who try to take them away. I am Derek Morrison, and I won my fight against the HOA. But more importantly, I helped make sure that others would not have to fight the same battle. And that, in the end, is what freedom is really about.